be. How do you explain the fact that nothing has changed over 9 months?
Time is up. Maybe Mr. Shea, you can be very...
Ça fait 9 mois qu'on attend. Quand même qu'on lui donnerait une minute de plus.
It's okay, it's okay. I'll
I can give him a few extra.
No, Madam Chair, if I could, in my round, look, rightfully so, these sections are comment and questions. That read as a comment, but I would allow them the opportunity to respond. There was certainly a lot placed and put to you in the last 3 minutes, and so I'll use my time to give you my 3 minutes to respond to his questions, because I think they're important questions, and Canadians and Quebecers deserve to know. Thank you.
Mr. Shea.
Thank you for your question, and thank you for your time. I think there's two parts to the question. One is what the Commission did, and one is what we have done in the past 9 months or whatever the period has been. I think in terms of what the Commission done, I'm really not in a position that I can speak for what Justice Rouleau did. I cannot speak to the independent Commission and how it structured itself and how it did its work. I can reiterate that it provided that 2,000-page report in both official languages and that there was public interpretation, but I appreciate that there are other questions, and I'm not in a position to answer what a Commission did. In terms of us, I am deeply committed to finding a solution to this. This is not my first time coming to a parliamentary committee. I am often guided by, in government we have open and accountable government is a document that was created under a previous government. It's been, reiterated by the current government. And there's a passage in there, and it's talking about, confidential information and cabinet competence, but I think the theme applies. And the theme is really that we should be working with committees to find solutions to provide answers and not simply say we can't provide information. And so my goal, certainly today, and I think in those letters, one of them is from Alex, who is with me, is in a conciliatory way in a goal of finding a solution. And so I don't know why there was a delay in that first letter. I apologize. I don't know the exact timing. Since I have been involved, we have sent 2 letters to try to explain this is what your request means. And so that first request that I mentioned, using the math that our colleagues mentioned earlier, 1 month for 16,000 documents, we're talking years and years and years to be able to provide the entire amount. And so we wanted to make sure the committee understood that and to offer other options. We offered to translate the evidence and said that would take $16 million in this period of time. And the one thing I would like to point out is we have not been sitting doing nothing. We have been working to go through a set of documents we had no idea what was in there to try to itemize them a little bit better. And that's why today I can offer to give you a list in very quick, very short order.
I do have an intervention. Sorry. I do. I'm going to take my parliamentary privilege to have an intervention on one point, because I want to think about, what is your scope of authority to accept a $16 million budgetary pressure on your department, given that we haven't come to subs, there's no additional money. How are you authorized to do that? Could you have been authorized to undertake that work absent of some other type of intervention from government?
That is a very good point, and one that was part of the reason we wanted to put the dollar value in there. There is no question that PCO would not have the ability to spend $16 million on translation without funding from Parliament, approved by Parliament. And so there's no question, whatever this committee was to ask for, if it was a large number like that, we would need to put in a funding request to the Department of Finance, and we would need to come to Parliament to seek that funding. We simply don't have the ability to spend that kind of money within a department our size. So thank you for that.
Thank you, Mr. Green. I move to Senator Harder, to be followed by Senator Karen Young. Senator Harder.
Thanks very much.
3 minutes.
I'd like to just follow up on the last train of thought. What is the de minimis funding, incremental funding, that could be proceeded with without having to go to Parliament for an additional fund? In other words, in your time frames that you're suggesting, you're assuming funding available. What I'm asking is, what are the roadblocks to getting that funding, and how much time are you adding for that?
Thank you for that. I think that would depend on the total amount. I mean, if we were talking $16 million, I think
Is that $3 million?
I think we could find a couple $1 million. I think $2 or $3 million we'd be able to find, especially where we are in the fiscal year. If that was split over 2 fiscal years, as an example, $1.5 million each year, we could certainly try to find that.
And my second, changing entirely, for my time remaining. I'd like to go back to your experience with previous commissions. This is unusual, you say. Can you describe whether there have been official languages complaints with previous commissions and how they were resolved, or whether there was access to either official language requirements that were added on after the commission tabled their reports? How extraordinary is this in your experience?
To the best of my recollection, I cannot remember any commission that I've been part of that has had a request like this. Certainly, I can say definitively for translation, this has never happened, that we've been asked for something that would cost tens of millions of dollars to translate. I do believe for missing and murdered Indigenous women and girls, we did need to update the website after the fact. I believe we added additional translations of Indigenous languages, and so I know that there is some precedent for that. But I do not recall anything that would be on the magnitude of what we're discussing here today.
Just summarize where we're at. If we responded to your helpful suggestion and identified documents which this committee, in its collective wisdom, would desire to have, if that list were modest in the sense of a couple $1 million, it could be done quickly, and we would be in receipt of that material within weeks.
It is the translation piece that I don't want to speak for my colleagues. We could certainly produce the list in a matter of weeks. The translation piece, I think we would have to kind of look at a little bit. It's 152,000 documents with, a short title and a little bit of information, but that would still take some time.
Thank you.
Senator Carignan.
Je reviens sur la
I'd like to come back to the question posed by my colleague, Mr. Fortin. On June 13th, 2023, this committee adopted a motion to suspend work until the documents were translated, and we sent the motion to you to request translation. On June 14th, what were you doing?
Well, exactly when I became aware of the request. I was not part of this committee work originally. I do know that in the early fall, there was a letter that was being drafted and sent to this committee responding to that request. I don't want to speculate. I don't know if that's related to Parliament adjourning and kind of timing. But absolutely, the internal discussions at PCO were, we would like to find a solution, and we would like to adhere to that idea of open and accountable government where we work with committees to find solutions. And so certainly that letter and the subsequent letter, the intention behind them was to very honestly disclose this is the work it would involve and open the door for discussions with the committee and the committee clerk to find a solution.
Mais vous avez rien fait de l'été, là, parce qu'il a fallu.
But we had to ask you again in October. We were all here saying, what is PCO doing? Are we going to get the translation? And we're the ones who asked once again, and then we got a response. So nothing happened over the summer.
So I can't speak to what happened over the summer. I can speak to in the fall. The recollection I have being involved was that we drafted a letter, we sent it to the committee. The committee, I believe, responded, and we responded a second time to try to articulate the cost of various options. We opened the door for translating just the evidence piece, as we understood that was an important piece, and it's been raised at this table today. And that's where the $16 million figure came from. But at the same time, we wanted to make clear that larger ask was over $300 million and many years to signal to the committee that certainly we would have a funding request that would go with that. And that was something that's more than PCO's entire annual budget.
Vous avez vu que le site web, la documentation.
You saw that the documentation on the website wasn't translated.
I will confess I don't spend a lot of time on the website. I think we would have known going in when it was handed over to us that they uploaded the evidence as the language that it was received in. My understanding is that is in keeping with the Evidence Act, and that there's actually concerns around if you do translation, it may actually change the meaning of evidence, and that is why it's done that way, as it's been explained to me by legal experts.
Il y a quand même 56 documents que c'est des représentants.
But 56 documents were presented and not translated, and nobody reacted to that?
I cannot speak to whether we had official languages complaints related to that specific, so I won't say nobody reacted to it. But that was, as I understand it, in keeping with the Evidence Act and not offside with the Official Languages Act as it's been explained to me. As mentioned before, we will see what the Official Language Commissioner comes back if one of the complaints relates to that, and if the Official Language Commissioner
Donc, il n'y a
comes with
personne à PCO puis à la
So nobody at PCO or the Rouleau Commission was concerned at all about both official languages.
We were absolutely concerned with both official languages. I remember the work that went into the Commission of Inquiry's final report. You may recall that the commission has a timeline. Unlike most commissions where there's an ability to extend the work, there was a very firm timeline. And I can remember that there were nights and weekends worked with the help of our colleagues at the Translation Bureau to I would say it was incredible amount of work to get this translated because we took just how serious it was to have this translated.
Colleagues, have a tight timeline. May I suggest that we go in this order? Mr. Motts, Mr. Maloney for 3 minutes, Mr. Fortin and Mr. Green for 2 minutes, and then we take our break. Otherwise, we're going to run into the next panel. Does that work? Okay, Mr. Motts, 3 minutes.
Thank you very much, Madam Chair. Mr. Shea, I understand Trudeau, Justin Trudeau, the Prime Minister, is the minister responsible for PCO. Is that correct?
That is correct.
So has he been briefed on this issue?
I cannot speak to whether he's been briefed on this specific issue. He has a parliamentary affairs team that would be briefed, but I think it would be more likely the government House leader who would be briefed on these types of issues.
And so then are you aware if there's any direction to PCO then from either the minister, the Prime Minister, the House Leader's office on respecting bilingualism or ignoring it?
I can say with confidence that the direction we receive from all ministers is to respect official languages, to ensure bilingualism, to ensure interpretation in cabinet meetings, to ensure documents are available in both official languages. That is absolutely a requirement for everything we do.
So just, I wanted to just clarify something that you said earlier. You mentioned a comment about the, we know the Official Languages Act in 15, I think it's 15, or Section 2, a witness can appear in the language of their choice, and the hearing of witnesses in the official language of their choice, and they should be disadvantaged. You made a comment about the Evidence Canada Evidence Act, or under the Evidence Act, and you weren't sure that the evidence only need to be unilingual. Did I misunderstand you, or can you clarify your understanding of the provision of providing of evidence to a commission in this case? Whether or not it was only required to be unilingual, or does it have to be bilingual?
My understanding of the Canada Evidence Act, as it's been explained to me, and I will preface every answer with I am not a lawyer, and do not wish to entertain a legal debate with a number of lawyers in the room. My understanding is that the Canada Evidence Act says that you have to post it, or you should post it in the language it was submitted in, and my understanding is part of the rationale behind that is because the translation could be seen as altering the evidence.
So you're saying posted. So that's an interesting comment. It's not a matter of just having the evidence presented to the commission. You're talking the actual posting of that on the website or in a document? Is that?
I'm saying my understanding is that when it's posted on a website, and just received, it needs to be kept in the language that it is received in, that it's not translated.
Okay, again, so what would be considered evidence under the Canada Evidence Act is a pretty broad term. So I'm just, thank you. I wasn't aware of that. I was just trying to get some
and I would add, if I could, witnesses were given the option to appear in the language of their choice as well. And so some witnesses appeared in English, some appeared in French.
Mr. Maloney.
Thank you, Chair, and thank you to all our witnesses for attending, for your patience and understanding. Mr. Shea, I don't know that anything here would qualify as technically a legal argument, so I don't think you missed out on anything. Just my observation. It seems to me we're going around in circles a little bit here. What we're trying to get to is if there is a smaller group of documents that we can obtain in a relatively short period of time at a relatively reasonable cost that are going to be relevant to our considerations here at this committee, and we can't seem to land on that. If I understand you correctly, this $16 million that you're referring to, you used a period of 10 months, I think, a couple of times tonight. In the letter that I've seen, it refers to a period of 12 months. In any event, it's going to be something just shy of a year. That is the smaller group of documents from which we would then be able to determine what documents we want. Is that an accurate summary? No?
No, and perhaps it's because I've not explained it well. The $16 million is for the exhibits that are on the website that we've been talking about that are currently in one language and not in both. That is the cost to translate those. The cost to translate a list we've not come up with, but it would be certainly less than that. It would certainly be something we could do more quickly because we're talking about one line per document as opposed to translating entire documents. So we could certainly come back very quickly and kind of quantify what that would look like for the committee. As a starting point, we think we could do that relatively fast.
And that's a list of documents without translating the actual documents themselves, correct?
Yes, that would be, whatever title they have saved it as. And so what we're seeing, and my colleague Alexandra has been looking through them, we see, email to so-and-so or document about X. So they tend to have enough information that I think you can get a sense of what they are. In addition, we can give a listing or a sorting by this is who. So we talk about how 88,000 of that 152,000 are productions from parties. We can sort them by party, and if you have an interest in certain respondents over others, we can prioritize those.
Okay, then we can pick and choose which evidence.
That is our goal:
choose.
is to give you a menu of options and allow you to pick. We are interested in this particular person that.
Can
that
you give me a
documents.
ballpark how long that list might be?
For us, we can do it in a matter of a couple of weeks, we think. I think the Translation Bureau, I'm loath to give an estimate on their behalf, but we're talking 152,000 times, 10 or 15 words. I don't know if they want to dare.
So it's a list of 152,000 items.
Exactly.
And so then we go through that list with a relatively short just description of what the document might be, and then we have to decide which of those documents we might want to look at. In order to look at those documents, you're then going to have to translate them and give them back to us.
Correct.
Okay. And in order to get those documents translated, you're going to have to request funding from somebody if it's more than a moderate sum of money.
I think the list we could probably do within
after the list.
our
I'm talking about the next stage.
And I'd add, if I could, I mentioned at the start 4 large kind of groupings. One of the groupings is these internal administrative documents. That's 11,000 documents. If the committee was to say, we're confident we don't care about the HR and the finance and the internal documents, well, we can take 11,000 off the table right off the bat and focus on the rest.
Okay, thank you.
All your time's up. Mr. Fortin, 2 minutes. Mr. Green, followed by Mr. Green for 2 minutes.
Merci, Madame la Présidente.
Thank you, Madam Chair. I'll be quick. Mr. Shea, I'm very happy to hear your suggestion of making up this list of documents, but I still have a question. Our motion on November 23rd requested an index with the title of documents, the number of pages. We were requesting that back in November, and now it's February 27th, and you still haven't gotten around to it. Mr. Smith was right. I don't want to just voice my dissatisfaction. I want actual actions. So you talk about a couple of weeks, but what is that, 2 weeks, 3 weeks? Can you give us a specific timeline?
I can't speak to the translation piece, but for the PCO piece, I think 2 to 3 weeks easily we could provide this, and we can provide it as it's available. So some of it, the government pieces, we can do very quickly.
J'ai juste 2 minutes, je m'excuse, monsieur.
I'm sorry, I only have 2 minutes. Mr. Limburner, apologies. How long do you think it would take to translate those documents? Thank you, Madam Chair. I think it also clarifies the term index If it's 152,000 lines, then obviously we could translate that a lot more quickly than the 124,000 pages. From what I understand, based on what Mr. Shea has said, the texts are quite short, but people with legal training would have to review them to make sure it's clear. So I think we could potentially do that work within a few weeks. I'm looking at you, Annie. Yes, thank you for the question. A colleague calculated this, 152 lines, so 2.2 million words. We would have to look into how we could get that translated, but it could be done. So are you saying 1 week, 1 month, 2 months? I would say 2 to 3 months. Okay, thank you.
Thank you. Part of our work is to try to come out with some sound recommendations, and in a hopefully foreseeable future, we'll be doing that in a draft report with recommendations back to the House some almost 2 years later. And I'm wondering if, through your experience in this, if you might agree with a recommendation that there be clarity around future interparliamentary or joint committees that that the legislation of the Official Languages Act be the guidelines for which we define our requests for information. I'm wondering if you would agree with that, given just the volume and complexity that we've kind of walked ourselves into.
I don't think it would be appropriate for us to weigh in on your deliberations and your recommendations, but we would welcome whatever recommendations you have. I would reiterate, we would like to work with committees, and I think the goal we should have as a government is to work with your clerk and work with your members to find solutions before they take months and months. And so I appreciate the frustration, and I would like us to learn from this and be able to respond more quickly to future demands.
Thank you. Mr. Limburger, I'm going to ask you a question. You guys on a good day are pretty stretched. Is that fair to say, given the fact that you got a bunch of freelance work as a Labor Party guy and a union supporter myself? I'm not a huge fan of opting out. I'm not a huge fan of AI. In a perfect world, what would your complement look like of full-time equivalent kind of collective agreement protected people within your department to adequately deliver a bilingual government?
So as I mentioned, Madame la Présidente, so as I mentioned, the number of translators we have at the Bureau, they're at 700. 100 of those are supporting specifically the work of the Parliament, and we augment our work when the type of work is possible. So, for example, if it's a not classified document, then we can leverage some other type of translation services that are not as critique, if you want, than the one that we do have. But as I mentioned, the number of translators is something that we are tracking extremely carefully, because we hire pretty much everyone who's coming out of university in that domain, and we definitely have the capacity of the Bureau at heart for that. And yes, we're fully prescribed. Also, somebody mentioned about the interpreters and their health. That's another area. That's when we lose an interpreter, that's a critical services. We have to reschedule. Some events happen on a regular basis. If I can just add something, Madame la Présidente, is that not only we mentioned 2-3 months for the index, but as I mentioned earlier, we can release as soon as we get some. So early release of those that are translated as they are being done, that would bring them to you faster. Merci.
Mr. Limburger, let me, on behalf of the committee, sincerely thank our witnesses. Your participation is greatly appreciated, and the information you provided with as extremely helpful for our deliberations. I shall suspend this meeting briefly while our next panel takes its place at the table. Colleagues, we will resume. I shall now introduce our second panel. We will hear from the witnesses and then in turn to questions from members of the committee. Appearing this evening before the Joint Committee, please welcome the Honourable Dominic LeBlanc, PC MP, Minister of Public Safety, Democratic Institutions and Intergovernmental Affairs. The Honourable Arif Virani, PC MP, Minister of Justice and Attorney General of Canada. The ministers are accompanied by officials from the Canadian Security Intelligence Service, Mr. David Vigneault, Director, no stranger to this committee, And from the Department of Justice, Shailene Curtis Mikuloff, Deputy Minister and Deputy Attorney General of Canada, Samantha Maislin-Dixon, Assistant Deputy Minister, Public Safety, Defense and Immigration Portfolio, and Jeanette Etel, Senior Counsel, Human Rights Law Section. From the Department of Public Safety, Emergency Preparedness, Sean Tupper, Deputy Minister, and from the Royal Canadian Mounted Police, Michael Deham, Commissioner. I remind the ministers that you will each be given 5 minutes for your opening remarks. Minister Varani knows this well. Mr. Varani, you may begin, followed by Mr. LeBlanc. Welcome back.
Thank you very much, Madam Chair, and it is a pleasure to be back. I remember these sittings quite fondly in terms of the timing. I remember being tired and hungry on most evenings, but it is a pleasure to see some very familiar faces and to see some new ones as well. So thank you very much for having me in this new capacity. So I'm here to discuss the declaration of the public order emergency, which took place obviously 2 years ago. I'm pleased to be back here at this committee. Since our government declared the public order emergency in February of 2022, there's been significant time, obviously, for review and for reflection on what was a very exceptional decision. The Public Order Emergency Commission, led by Commissioner Rouleau, was convened as one of the many accountability mechanisms inherent in the Emergencies Act in terms of the way the statute is structured. It found at that commission that the declaration of the public order emergency met the legal threshold in the Emergencies Act, and that it was appropriate and that its measures were effective. Obviously, this committee is also a statutory mechanism which ended up reviewing the operations of the declaration, and I was very privileged to be part of that work and that review. And I look forward to you concluding your work and seeing the final recommendations, which I believe were in draft format last time I was sitting at a table over where Ms. Romanado is sitting right now. Je tiens à rappeler au comité que la décision d'invoquer la loi.
I'd like to remind the committee that the decision to invoke the Emergency Measures Act was not taken lightly and required consultation with leaders across the country, including all provinces and territories. The measures we took were temporary and narrowly tailored to the emergency situation based on the information available at that time. All these temporary measures came to an end when the declaration of emergency was revoked on February 23rd.
The Act was a reasonable response to the extraordinary context of February 2022. I think time is fading in some of our memories of what the situation was approximately 2 years ago, including the very dynamic and the continuously unfolding situation in several parts of the country. As we stated in the explanation of the reasons for the declaration of emergency, there was a risk of serious violence that was a crucial consideration supporting the decision to declare a public order emergency. The sole purpose of the temporary measures that were made was to bring about a swift, orderly, and peaceful end to the circumstances that necessitated the declaration of the public order emergency. As required by the legislation, the Emergencies Act, the measures were consistent with the Canadian Charter of Rights and Freedoms, and former Minister Lametti provided this committee with a charter statement outlining the charter considerations that were engaged. We recognize that the declaration of a public order emergency temporarily allowed the granting of extraordinary powers. However, the legislation balances this with a range of accountability mechanisms. Nous reconnaissons que l'invocation de la loi sur les mesures.
We recognize that invoking the Emergencies Act temporarily conferred extraordinary powers, but this had to be put into balance with a mechanism of accountability. One of its most important mechanisms is that when the act is invoked, the government is required to hold an inquiry at the end of the emergency. Commissions of inquiry are independent bodies charged with investigating a matter of public importance. They perform two important functions. They draw conclusions of fact and they make recommendations for the future. When unexpected, disruptive, or otherwise significant events occur, that affect the lives of Canadians, the public has a right to know what happened, why it happened, and to learn from these experiences.
As you are all well aware, at this committee, our government was found to have acted reasonably and consistent with the law by Commissioner Rouleau in his report of the public inquiry into the 2022 public order emergency. That report by Commissioner Rouleau was released in February of last year, 2023. While I cannot comment on ongoing litigation, I can say that our continued position is that the government's actions were reasonable and justified based on what we knew at the time of the invocation. Les occupations et les barrages constituent une menace.
The occupations and blockades pose an exceptional and unprecedented threat to our economy and across our country. I am proud that we were able to use the legal tools at our disposal to find a peaceful resolution to a national emergency that threatened the very democratic values that contribute to the freedom of all Canadians.
Madam Chair, merci beaucoup.
Minister, and we'll turn to Minister LeBlanc.
Thank you, Madam Chair, honourable senators and colleagues in the House of Commons. Thank you for inviting me here. Unlike my colleague Arif, this is my first time at your joint committee. It's a privilege to be here. And Madam Chair, thank you for introducing the senior officials from the public safety portfolio who are accompanying me here this evening. I appreciate the invitation. The invitation was obviously following the federal court's ruling on the invocation of the Emergencies Act in 2022. I'm happy to be here with my colleague, the Minister of Justice and Attorney General, who indicated obviously the government's position with respect to ongoing litigation matters. Ceci étant dit, je souhaite aujourd'hui
Having said that, I would like to take this opportunity to discuss with the honourable members of the committee the exceptional circumstances which led the government to invoke the Emergencies Act in February 2022. These circumstances included unlawful country-wide protests that presented a threat to the safety of Canadians as well as disruptions to critical infrastructure.
Confronted with illegal blockades at border crossings and vital trade corridors. This impacted our economy, industry, and the jobs and livelihoods of many hardworking Canadians. Indeed, the blockade of the Ambassador Bridge alone affected about $390 million in trade every day. This bridge supports 30% of all trade by road between Canada and its most important trading partner, the United States of America. And I remember during those days multiple conversations I had with the Premier of Ontario, Premier Ford, about the importance of working with his government and using every available tool to bring this to a peaceful conclusion as quickly as possible. Coupled with the blockades, the illegal occupation of our city streets also presented very real threats to Canadian businesses, both big and small. Participants in these activities used a number of tactics to threaten and intimidate local residents and businesses. Their activities disrupted the peace and contributed to a general sense of public insecurity. Prior to the invocation of the Emergencies Act, citizens, municipalities, and the province of Ontario all participated in court proceedings seeking injunctive relief to help manage these threats, and a class action lawsuit was filed on behalf of residents of Ottawa. Chers membres du comité,
Honourable colleagues, given these exceptional circumstances, the government maintains, as my colleague indicated, its position that this unprecedented situation constituted a public order emergency. The government therefore also maintains that its use of the Emergencies Act was both necessary and lawful. And as you know, having studied the issue for some time, the decision was supported by the Commission, as my colleague indicated in its final report. After reviewing more than 85,000 documents, interviewing 139 individuals, receiving testimony from 76 witnesses, and hearing from 50 experts, the Commission concluded that the very high threshold required for the invocation of the Act was met.
The Emergency Commission found that the high threshold to invoke the Act was met. The Commission's report also provided recommendations that the government is carefully considering, and I hope to have, as early as next week, some details in terms of the government's specific response to the thoughtful recommendations of the Rouleau Commission. In particular, we're obviously examining recommendations to improve collaborations between jurisdictions, support community safety, help strengthen our capacity to respond to similar events of national significance in the future. So with that, Madam Chair, I'm obviously very happy with my colleague to answer any questions that committee members might have.
Both very much. We will move to our first round. First round will be 5 minutes, and we'll start off with Mr. Brock. 5 minutes.
Thank you, Chair. Good evening, ministers and supporting cast. Thank you for your attendance tonight. It's been a long time coming to get both of you here and your supporting entourage, and we're very grateful. So I want to start off by just opining that it's of no surprise to me, and I'm sure many members on this committee, that both ministers doubled down literally on the same talking points that we've heard from this Liberal government throughout the last 2.5 years, but most importantly after the ruling of Justice Mosley. In my respectful opinion, the federal court ruling provided a massive political humiliation for the Justin Trudeau government. So to you, Minister Virani, were you given a copy of Justice Mosley's decision before it was publicly released at 1:03 p.m.?
I received Justice Mosley's decision when it was a matter of public record.
Thank you. So literally 14 minutes later, Minister Virani, at 1:17, both you and Deputy Prime Minister Freeland issued a release indicating that both of you were planning on appealing. Prior to you making that announcement publicly to Canadians, did you read all 191 pages of Justice Mosley's decision in the span of 14 minutes? Yes or no?
I was assisted by people who were with me, and we jointly reviewed the decision.
And did those people jointly review all 191 pages in 14 minutes?
We made an assessment of the decision, and you've seen the notice of appeal that is a matter of public record. We have tremendous respect for the federal court and for all of the judges therein. Reasonable people can have disagreements about matters of law and mixed matters of law and fact.
Thank you. How long does it take the Justice Department, how long does it normally take the Justice Department to publicly state whether they are going to appeal a court judgment?
I'm not aware of any sort of average in that regard, Mr. Brock. What I would say to you is that it's entirely context specific. It's case-by-case determination.
In my 2.5 years as a parliamentarian, Justice Virani, I have witnessed your government opining on several Supreme Court of Canada rulings and various provincial Court of Appeal rulings, and the talking point has always been we need to review the decision, we need to measure a response, and we will decide in due course whether or not we will launch an appeal. But in this particular case, you clearly didn't read all 191 pages, but it was important to you because you were politically humiliated. The entire government was humiliated, particularly your Prime Minister, Justin Trudeau, that you illegally invoked the Emergencies Act. That's why you received your marching orders, probably from the Prime Minister, if not from the PMO, to publicly state your intentions to appeal. Yes or no?
You're mischaracterizing exactly what I just said to you in my previous response. I said I was ably assisted by others who were there in the room, and we jointly reviewed the decision.
Minister Varani, you were a member of this very committee when on May the 30th, 2022, we ordered the production of the government's legal opinion. That motion passed unanimously. You were in support of that, Minister Varani. Now that you're in a position to do something about it, will you turn over the legal opinion?
The opinions and advice are matters of privilege, which you'll appreciate as a fellow counsel, Mr. Brock. So those are, and I believe you've received a response both from the previous Deputy Minister, Mr. Daig, and also the current Deputy Minister who's sitting beside me to that effect.
I don't appreciate that, Minister Varani. What is the government hiding?
Mr. Brock, we can discuss the importance of solicitor-client privilege, but I'll put it in a pithy manner. It is an important principle that has existed for literally centuries in our joint profession that you and I both...
There's precedent. If I interrupt, this is my time. If I can interrupt.
Madam Chair, can I finish my response?
Precedent. Minister
Point of order.
Varani, this is my time.
Point of order. Excuse me. It's very difficult for the interpreters to interpret when you talk over top of each other. So, Mr. Brock, I'll set you back to 45 seconds. Can you just shorten your question so we can get an answer in?
Mr. Varani, there is ample precedent of numerous governments, including this particular government, to have waived legal opinion, to have waived solicitor-client privilege. If the Prime Minister, to Justice Rouleau, was so serene and confident in his decision to invoke the Emergencies Act in light of Justice Mosley's repudiation of the invocation of that act, what is the government hiding?
Briefly, please, Mr. Brown.
I would say solicitor-client privilege is foundational to the development of legal advice in a candid and frank manner between a solicitor and their client. It is a sacrosanct privilege that has existed for centuries in British common law, and it is one that this government firmly believes in terms of producing.
And you, sir, have the
legal
position
advice.
to waive that privilege.
We'll now move to Mr. Maloney. 5 minutes.
Thank you, Madam Chair. I appreciate that opportunity. And ministers, other witnesses, I really want to say how grateful I am for you being here today, especially it's an evening meeting. My question, I guess, is for both ministers, but perhaps Minister Varani, it would make sense to start with you, given your background in this committee. Look, I've only recently joined this committee. In fact, this is my third meeting. You said you look back fondly on this. I look forward to the day that I can look back fondly on this committee. But unfortunately, as we've just witnessed, this committee has become highly politicized, and it's lost its way, frankly. If you look at the Emergencies Act legislation, there's two things. There's this committee and there's the Royal Commission. Both of them are put in place for very specific purposes. One is to look at the conditions that were in place that it required the government to invoke the legislation, and one, which is this committee, is to look at what goes on during the time when the committee or the legislation had been invoked, or the Emergencies Act had been invoked. We're about 2 days away from 2 years, two days away from the 2-year anniversary when it was invoked, and a few days away from 2 years to the anniversary when it was revoked. Now, I would say that this committee has gone far beyond its scope and far beyond its mandate, and I would like to hear your view on that, and perhaps Minister LeBlanc, too.
Thank you, Mr. Maloney, for the question. I'll say to you, my interpretation of the statute as it's plainly written was exactly the same when we first commenced at this committee, and many people who are members of this committee made the exact same argument that this was meant to be an oversight during the period of the invocation of a declaration. I think at this point we are where we are, but what I would say to you is that there still is, it's unfortunate and somewhat ironic that something that was commenced after the constitution of this committee, the Rouleau Commission, has concluded before this committee has even wrapped up its work. But I think there is still ample room for this committee to do the important work that a joint Senate House multi-partisan committee can do, which is actually provide recommendations. And providing those on a timely basis, as in very, very soon, would be helpful to the deliberations of all parliamentarians in terms of reflecting on the invocation and reflecting on the way forward.
Okay, maybe, look, I mean, you just had a discussion with Mr. Brock about the production of the opinion that was provided with respect to the invocation of the Act. Leaving aside the issue of solicitor-client privilege, I think that discussion is a glaring example of how this committee has gone beyond its mandate, because given the terms of reference for this committee, that opinion has no relevance here whatsoever. So my next question really is in terms of Minister LeBlanc had suggested he's going to have some response to Justice Rollo. The two of you, particularly you, Minister LeBlanc, are going to put forward some proposals on how the legislation can be improved. Unfortunately, we might be in a situation where you don't have a report from this committee. So I'm wondering if you have any thoughts about how the legislation could be reviewed now, and would one of those proposals include redefining the scope of this committee in terms of a time frame so we don't run into this situation where we go beyond its scope, beyond the time, and turn the committee into something it was never meant to be?
Madam Chair, thank you, Mr. Maloney, for the question. My understanding of the statute, what I was briefed following the invocation and then rescinding the invocation, I thought my understanding of the role of this committee was as you described and as my colleague Arif, I think, also endorsed. Next week, I will set out the government's response to all of the Rouleau Commission recommendations. You properly noted, Mr. Maloney, that he does, in the Commission report, make suggestions around potential legislative amendments, some around the Emergencies Act, the definition of in the CSIS Act. Those are complicated undertakings, and I think the government and Parliament would very much benefit from the advice of this committee because it's a committee representing both houses of our Parliament. I think there's a unique opportunity to hear from parliamentary colleagues on how Parliament may consider those legislative amendments. I'll be setting out specific government responses to some of the more administrative, police of jurisdiction issues that the Commissioner identified. And as you would know, a number of the recommendations also touched other orders of government. But we will be, I hope, providing a detailed response, as we committed to do. But I totally share your view, if I understood it, Mr. Maloney, that it would be certainly helpful, I think, to Parliament to benefit from the view of a committee of parliamentarians that has studied this issue in terms of, are there legislative steps? The Emergencies Act, as we heard, is a piece of legislation that's almost 4 decades old. The first time it had been invoked, so it would be a thoughtful exercise, I think, that would benefit Parliament.
Time is up. Mr. Fortin.
Merci, Madame la Présidente.
Thank you, Madam Chair. First of all, welcome, everyone. Welcome to the ministers and to all our guests. A question for Minister Virani. You were saying earlier that we've been sitting for quite some time, and the Rouleau Commission has already given in its report. You were here in June 2023, and you'll remember that we voted for a motion requesting the translation of all documents before the Rouleau Commission. What would you say if I told you that today, 9 months later, we still haven't received any of those translated documents, and the PCO hasn't even started working on that translation project? I can't really speak to that. I remember when this was raised in June, and what about the delay, Mr. Minister? 9 months later, nothing has been done. Are you surprised by that? I have no information on the topic. I think you should ask the witnesses who appeared before us. Thank you. Minister Virani, you say that the decision to invoke the act was made based on the information we had. Now, Minister Leblanc, you were in cabinet when the act was invoked. Do you agree that it was based on the knowledge you had at that time? Absolutely. We discussed the issues broadly in different forums, and we came to a decision that we believed was reasonable and legal based on the information we had at that time. You know that at this committee, this all happened 2 years ago, and we've We were struck a year and a half ago, and the evidence that we heard, well, I didn't hear anything that seemed to justify the invocation of the act. The blockade at the bridge was dismantled before the invocation of the act, and then there were trucks downtown, of course, but the chief of police, Mr. Soli, came to speak to us to say that he had requested a certain number of police officers to dismantle the blockade here downtown, and it happened after he had left. Now, I don't really understand what the justification was. It seems to me that invoking the act was a little excessive. The only thing that I wonder is all ministers who've appeared here say, look, I understand, but we based our decision on a legal opinion that we were given. So do you agree with what your predecessors have said, that you cannot share that legal opinion with us? Are you able to justify the invocation